Hello, I'm Scott Edward Walker, and I'm the founder and CEO of Walker Corporate Law Group, which is a boutique corporate law firm specializing in the representation of entrepreneurs. You know, I've been doing deals for over 15 years now, including nearly 8 years at 2 major law firms in New York City. And during that period, I've seen certain mistakes over and over again made by entrepreneurs in connection with capital raising. What I thought would be helpful is just to share with you 5 basic mistakes that I've seen in no particular order. You know, mistake number 1 is playing securities lawyer. You know, the law is pretty clear here. A company may not offer or sell its securities unless 1, it's registered with the Securities and Exchange Commission and applicable state commissions, or 2, there's a transaction or security exemption. Now, what startups and entrepreneurs generally rely on is a so-called private placement exemption under Section 4.2 of the Securities Act of 1933 and Regulation D, which is the safe harbor promulgated thereunder. I mean, this is really complex stuff. And it's not the time for the entrepreneur to play securities lawyer. Non-compliance with applicable securities law can lead to serious adverse consequences, including rescission rights to the investors, which means they can basically get their money back, fines, penalties, injunctive relief, and possible criminal prosecution. You know, mistake number 2 that I've seen is entrepreneurs going out and selling stock to friends and family who are not accredited investors. So the rule of thumb here, and most securities practitioners will recommend this, is when you're doing a private placement, go out and only offer and sell securities to accredited investors under Rule 506 of Regulation D. And there's 2 principal reasons for that. Number 1, Rule 506 preempts state law registration requirements. And number 2, there are no specific disclosure requirements if you're selling stock to an accredited investor. Though I would probably recommend doing some form of PPM or a summary plus risk factors. So what's an accredited investor? Well, for purposes of entrepreneurs, when you're going out to friends and family, it has to be an individual who has net worth in excess of $1 million or joint net worth with a spouse in excess of $1 million. Or number 2, income in the last 2 years in excess of $200,000 or with the spouse in excess of $300,000 and a reasonable belief that they'll maintain that income in the current year. If you're not selling stock to accredited investors, you're opening up a Pandora's box of potential disclosure issues and regulatory issues. Mistake number 3 that I've seen is entrepreneurs advertising or soliciting investors. Now, other than certain very, very narrow exceptions, the rule in connection with private placements is that there's no general advertising or general solicitation permitted. Now, those terms have been broadly construed under SEC no-action letters. Advertisements mean any kind of ad, notice, article, or other communication, whether it's in a magazine, newspaper, on the internet, broadcast over radio or television. And soliciting means you cannot go out and telephone or send mailings or emails or other transmissions to other investors unless there's a pre-existing and substantial relationship. Now, what does that mean? I mean, that means there has to be a business relationship that's in place prior to the actual offering that permits the issuer to determine that the offeree is indeed a suitable investor. Mistake number 4 that I've seen is entrepreneurs using unregistered finders to sell stock. Now, what's that? Well, when an entrepreneur goes out and wants to raise money, he often gets third parties involved, whether it's an investment banker, a consultant, whatever the name is. These people will then go out and are given a commission if they sell stock. The problem is if they're acting as a broker-dealer, which is broadly defined under the 1934 Act, they have to be registered with the SEC. If they're not registered, there's a violation of securities law, and the entrepreneur and the issuer has serious, serious problems. Finally, the 5th mistake that I've seen is entrepreneurs selling preferred stock to angels. So it doesn't, you know, when an entrepreneur or a startup goes out and wants to raise angel financing, it doesn't make practical sense to issue preferred stock unless the offering is in excess of, say, $750,000. Why? Because preferred stock financings are complex, they're time-consuming, and they're costly because of the legal fees. And you're going to have to do some type of valuation, which could lead to substantial dilution to the entrepreneur. The better course of action is just to issue convertible notes, which are relatively simple, relatively inexpensive, and relatively fast. And then the valuation can be just pushed on to the Series A. So those are 5 common mistakes that I've seen in connection with capital raising. I hope they're helpful. If you have any questions or comments, please just shoot them to me through my blog at walkercorporatelaw.com/blog. Thank you.